Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have three interesting cases and lots of good lawyers. It's good to have you here. In the first case, it's styled Riley versus Bondi. Ms. Profaci. Did I mispronounce your name?
It's Profaci.
I do that a lot. I'm sorry about that. It's good to have you with us. And we appreciate your work. You've already been to the Supreme Court with this case.
Yes.
Congratulations.
Thank you. May it please the court. My name is Elizabeth Profaci, and I represent the petitioner in this case, Mr. Pierre Riley. If removed to Jamaica, petitioner will be killed by a local gang leader with the acquiescence of the Jamaican government. The immigration judge, the finder of fact in this case, observed petitioner on direct and cross-examination, listened carefully to his testimony, asked him questions, and reviewed extensive background and country conditions evidence. The immigration judge found him credible and granted him relief under the Convention Against Torture. Absent clear error, the Board of Immigration Appeals may not substitute its own view of the evidence for that of the IJs. However, in this case, the BIA reweighed the evidence and substituted its view of the evidence for that.
How about jurisdiction?
There is jurisdiction in this case, Your Honor.
Yeah, well, I know, but that's your position, but explain to us how you have jurisdiction.
Sure. So Section 1252.
I mean, we're going to get to your merits, but
Sure. So Section 1252 confers jurisdiction on this court to review final orders and other issues contained therein. And so here, Section 1252A4 provides for direct review of claims arising under the Convention Against Torture, as petitioner brought here.
Can I ask just one question about that position? So that was the position you took the first time you were before the Fourth Circuit on appeal, and we rejected it. And I know that was an unpublished opinion, but is it law of the case?
It's not, Your Honor. Our position is that following the Supreme Court's order overturning this court's ruling on jurisdiction, the jurisdictional question is revised anew.
Well, it's sort of, I mean, our law on this is not 100% clear what happens when the Supreme Court, GVR is one of our opinions, sort of what happens to the parts of that opinion that weren't touched.
Certainly, Your Honor. So petitioner's position is that there's jurisdiction here. The Supreme Court clarified what the final order of removal is in this case. And so here, the main issue was the timing. And with the timing issue gone, petitioner is able to bring forward his claim.
So help me there. Why do you say the timing issue is gone? Because the government's concession that they aren't going to enforce the 30-day issue?
Yes, and so because now petitioner had filed his petition for review after the BIA's order and not 30 days after the final order of removal, now with the government having waived that deadline, petitioner is able to proceed and this court is able to exercise jurisdiction.
But you still, I mean, do you disagree with the proposition that aside from timing, you must be seeking the review of a final order of removal in order to have the review of your CAT claim?
We do disagree that we need to challenge the final administrative removal order in order for this court to have jurisdiction.
So your position that we have jurisdiction is under the belief that you don't have to have a final order of removal to review CAT?
That we don't need to challenge that,
And
yes.
is the statutory basis of that 1252A4?
It is, that's the statutory basis, and the zipper clause here, B9, also supports that because Nasrallah clarified that the zipper clause here just dictates that all claims be brought together. And so in an ordinary case, right, putting the timing and the expedited removal issue to the side, in an ordinary case, the case comes up from the IJ to the BIA, and the BIA might deny removability and deny the CAT claim, and then petitioner only challenges the CAT claim. In that case, they're only bringing forward a challenge to the CAT claim, and so they don't need to challenge their removability for this court to have jurisdiction. Here, it's a little bit wonkier because of the expedited removal issue and the timing issue, but generally, following those same principles, you don't need to bring a frivolous claim challenging removability for this court to exercise jurisdiction. And so, reading those together, these situations, it makes sense that perhaps this court will require that we challenge the FARO by form and list it in the petition. But for this court to truly address the merits of our claim, we don't need to bring a challenge to removability.
Do you read Nasrallah or Riley to support that view or just not to reject that view?
We read Nasrallah to support that view.
Because that's interesting. I mean, because I agree Nasrallah cites A4 as one of the provisions, but it really cites 1252 or whatever, I may have the statute wrong, but the other statute that talks about reviews of CAT, and you know, there's at least a reading of that the CAT review exists, but must be along with a challenge or review of the order of removal. I know you disagree with that. It just seems like every time in Nasrallah they say it, they say along with the order of removal. So I'm struggling with how we don't have to have an order of removal to review the CAT claim, or a petition to review the order of removal.
Sure. If I may, in Nasrallah, respondent in that case raised a similar argument, saying that the Foreign Affairs Reform and Restructuring Act requires that the final order of removal be brought up at the same time as the CAT claim, so they had to come together. And the Supreme Court firmly rejected that in saying that the Real ID Act provides for direct review of Section 1252A4. And that's, I believe, in the same paragraph on page 585 of the court's opinion in Nasrallah.
I'm hoping you can help me sort of get my hands around sort of practical implications and the stakes of this argument, because you know, you start by saying you don't have to bring a frivolous or just kind of make weight challenge to the final administrative removal order. But that is only because of the waiver of the time bar, right? The Supreme Court says in Riley, everybody else is in fact going to have to bring kind of a made-up fake claim against the FARO. You're in a different position only because of the waiver?
Yes, Your Honor, but if I may clarify how we envision this process moving forward in the future, our understanding is reading Riley v. Bondi, the Supreme Court's opinion, is that in these cases, petitioners will flag that they're going to challenge their FARO and that they have a withholding claim processing, and that they may then, at the conclusion of those withholding proceedings, may then choose which orders to appeal.
Wait, I'm sorry. The part where the Supreme Court says in Riley, look, this isn't going to be such a practical problem because going forward, people can challenge within 30 days the FARO, tell the Court of Appeals, don't rush because I'm waiting for my withholding only proceedings, and then the Court of Appeals can stay the appeal and hear everything at once.
That's right. And so in this case, the issue is really just because there is, for lack of a better term, a misunderstanding of what a final order of removal was. Previously in this court, the rule was that you had to appeal from the BIA's position.
But you're agreeing that that's the process that the Supreme Court has outlined in Riley. So there are going to have to be these kind of make-weight appeals of FAROs, even if someone is only interested in actually challenging the outcome of the withholding-only proceedings?
That's how we anticipate
Okay.
that process will go.
Okay. So what's at issue here is just however big it is, but the set of people who have a waiver of the time bar, because otherwise you really got to get in and challenge the FARO within 30 days.
That's our understanding, yes.
Okay. Do you have any idea how many people we're talking about? Like, is this 5 people? Is it a whole bunch of people? I mean, I'll ask your colleague this too.
Our understanding is generally only about 300 people are granted deferral of removal under the CAT year.
No, I'm sorry, how many people have a waiver of the time bar? Left over from the last administration, I assume is what we're talking. I'm just trying, is this like, we're having this huge, big discussion, and I'm actually just trying to figure out how many people are affected. How many cases are we talking about?
Our understanding is that it's a handful, but I do believe my colleague would be in a better
Okay,
position to answer
thanks.
that question.
Now, you have a motion pending to amend the petition,
Yes, Your Honor.
and you're still sticking by that? Your position's the same on that?
Our position is the same, that might be unnecessary, but if this court determines that by form our petition was lacking,
No, I'm not, unconditionally, you sponsor that motion.
yes.
You wanted it granted.
If this court needs
Well,
to,
you're kind of conditioned, that's what I'm asking. You want the motion to be granted.
so that this court can have jurisdiction, yes. If this court finds otherwise, our client will likely be returned to Jamaica and killed, and so we're doing whatever we can to sort of protect his life here.
And so you want us to grant the motion that's pending?
If this court determines it needs to exercise jurisdiction, yes.
Counsel, as I read your motion, petition to amend, you're asking that we clarify that your petition for review includes the order of removal in terms of the challenge, is that right?
If necessary, yes.
Yeah, I appreciate the necessary part. But do you make any challenge to the order of removal? It looked like you just wanted us to construe it formally to challenge order of removal, but you're not challenging anything about the order of removal.
We have no challenge to removability in this case.
What about the merits?
So on the merits, Mr. Riley will be killed if he's returned to Jamaica. In this case, the immigration judge found him credible and granted him relief under the CAT. The BIA then impermissibly reweighed that evidence and substituted its own view for that of the immigration judge. The immigration judge found Mr. Riley credible, and the BIA, while it said that it agreed with that credibility determination, then proceeded to disregard Mr. Riley's testimony throughout, referring to it as speculative. The BIA seems to argue that Mr. Riley needed to provide additional corroborating evidence, which he doesn't need to under the regulations and this court's precedent. However, Mr. Riley submitted troves of corroborating evidence. He submitted sworn testimony from family members, which supports his claim, and he supported ample country conditions and background evidence. And so, for example, the BIA ignored important legally significant evidence when it's misconstrued petitioner's claim by calling it speculative. For example, the Board of Immigration Appeals points to the fact that Mr. Riley said that he knows that the local gang leader killed his cousins because the associates brag about these things. But the BIA seems to construe that as showing that Mr. Riley's claim was speculative. However, that statement comes in a long paragraph in Mr. Riley's testimony in which he explains how he knows that Don will kill him if he's returned and that Don killed his cousins. And so by ignoring the other aspects of the of Mr. Riley's testimony and the evidence, the BIA then proceeds to reweigh the evidence that the immigration judge considered.
Can I just ask you a question about the standard of review here? What if I thought, like, oh, this is a close case, like you could reasonably come out either way on this? Does that mean, and I think the government sort of suggests this, that then I should defer to the BIA because its view is supported by substantial evidence? Or does it mean that the IJ wins because the BIA is only supposed to be reviewing for, what's the standard of review here?
The standard of review is that this court reviews the BIA's, it's kind of a long answer, Your Honor, I apologize.
fine, that's
But the BIA reviews the IJ's decision for clear error, and then this court reviews the BIA's application of that standard of review, to, at least for the clear error, de novo. And so in this case, right, the question is whether the BIA substituted its view of the evidence for the immigration judges. And in this case, it's pretty clear that that's what happened.
And that's the question I review de novo, no deference to the BIA, even though the BIA says we're applying clear error review.
That's right, because reading the BIA's decision, it's quite clear that they are reconsidering the evidence de novo, rather than finding that the IJ's findings of facts were illogical, implausible, or completely without support from the record as a whole.
But if you, that's, I appreciate that position, but if we believe the BIA was acting in accordance with its authority on review, we would review that for clear error, correct?
This court would review the BIA's factual findings for substantial evidence, yes,
Right.
Your Honor.
Substantial evidence.
For substantial evidence.
Yeah.
Yes. However, in addition to that issue, the BIA did.
But the IJ found the petitioner was credible.
That's right, Your Honor. And that credible testimony alone, under the regulations and this court's precedent, can meet the petitioner's burden of proof in this case.
So is it your view that if the immigration judge finds the petitioner credible and that's kind of the end of the, I mean, does the BIA, its hands are tied then?
No, Your Honor, the BIA reviews the immigration judge's findings for clear error, and that.
Someone can be testifying credibly in the sense that they're not lying, and you know, their testimony may be insufficient or not lead to the conclusions that the petitioner, you know, claims they lead to.
That's right, and using an extreme example, if a petitioner testified that he's being persecuted by a green-eyed alien, the BIA would find that, and the IJ found him credible and found that as fact, the BIA would be able to find that that was illogical or implausible or unsupported by the record as a whole. And so the BIA doesn't need to.
But I'm sorry, in that example, is the BIA finding clear error in the credibility finding?
In the fact finding.
So you could credit, you're saying you can credit the petitioner believes he's being persecuted by the green monster?
That's right, and
Okay,
then the finding of fact that was true would be illogical, and so that would be clear error. And here, the BIA doesn't have that finding, but in addition.
I think, I'm sorry, because this does seem what's hard about the case for your client is that you can credit his testimony. He believes that this guy is the one who's responsible for the killings and that that this Don person will kill him if he comes back. He 100% believes that, but as the BIA says, he doesn't have any firsthand knowledge. Like most of our cases, or at least it seems to me, many of our cases, you know, once you credit the person, there's firsthand knowledge. He says, Don told me he'll kill me if I come back, and we're missing that here. So there is at least a bit of a gap between crediting the petitioner and making the case. And that seems to be what the BIA was concerned about.
Certainly. My time has expired. May I continue?
You answer questions as long as you
Okay.
get them.
I just want to make sure.
Yeah.
So in this case, petitioner doesn't have to have firsthand knowledge, and the preamble to the regulations for the withholding-only procedures, they explain that often the evidence that the immigration judges deal with is hearsay or isn't based on firsthand knowledge, and that's okay. These judges are skeptical, and they're well-trained to make these discerning decisions. But putting aside the fact that petitioner may not have firsthand knowledge that Don killed his cousins, that just provides background and motive for the reasons that Don wants to kill petitioner. Petitioner knows that Don wants to kill him. Jamaica's a violent society. It might not make sense to us why Don wants to kill petitioner.
And what's the best record evidence that Don wants to kill the petitioner?
Don has made calls to several members of petitioner's family, making it clear that he
There
will.
were affidavits from several members of the family as well, right?
That's correct.
He testified and had affidavits
He did.
that
But did-
backed him up.
But the family doesn't say it's Don making the calls, right? They just say, we're getting the calls are coming in.
Yes,
I
and
don't know.
then I believe it's either the brother or the stepfather who makes it clear that they understand that the calls are coming from someone known to petitioner. And in Aritas Deras, this court dealt with a similar issue, where in that case, asylum, but very similar, where the family members' credible affidavits made it clear that a gang member or a leader was calling them, making threats. And in that case, this court said that they don't need to identify the person by name in order for it to make sense. And so here, petitioner credibly testified, filling in the gap as to who the threats were coming from. And together, the IJ considered that evidence and weighed it and found that Don is likely to kill petitioner if he's removed to Jamaica.
Thanks very much.
Thank you.
You've saved some time, I think. Ms. Farrell? Good to have you with us, Ms. Farrell.
Thank you. Good morning, Your Honors, and may it please the Court. Corey Farrell on behalf of the Attorney General. This case presents a jurisdictional issue which this court must resolve before it can proceed to the merits of this
Well,
case.
We don't have to resolve it if we grant the motion to amend the petition, right, to add the FARO?
If you grant the motion to amend, you
Can I
would,
ask why we shouldn't just do that? I mean, the court in Riley literally says, here's how this is going to go. You're going to file a fake appeal from your FARO. That's going to buy you time. You'll tell the Court of Appeals, just don't do anything till withholding only is finished, and then you can challenge everything at once. And then they say, and don't worry, because if the petitioner doesn't know about trying to file the fake appeal from the FARO within 30 days, the government can do what it's done here and just waive the timeliness issue, so they can just amend it later. Like, what is the problem? All that they want to do is exactly what the court says to do in Riley.
and Your Honor, I don't, the government does not read Riley to say you can file a fake appeal of the
It says you can file an
FARO.
appeal of the FARO, even if what you're concerned about is the withholding.
And here petitioner has never challenged, even in the motion to amend, anything
Clear
about
that
the
that's what the
FARO.
court is contemplating in Riley. They're trying to figure out how are we going, how is someone who is like Mr. Riley, I mean, they're talking about the same guy. All he wants to appeal is the withholding only proceeding. So here's what people like that should do. File a, let's call it a protective appeal from the FARO within 30 days, and that will allow you to do what you really want to do, which is challenge the withholding only proceedings. I just feel like the court laid this out for us.
And the government's position is that there has been no challenge to the FARO, and at this point in the proceedings, that it's
But you've
very
waived the
late.
timeliness issue. What do you
Waived the
care?
timeliness
So why do you
issue.
care
You're
that-
not backing out of that waiver, are you?
No, the timeliness
I mean,
issue,
They even waived that before the Supreme Court.
that is correct, Your Honor. The timeliness issue is separate and apart from challenging a final order of removal. And here Riley tells us,
So your counsel, if I understand, you're not waiving the timeliness, but your position is at some point you have to challenge the removal order, right?
that the government is waiving the timeliness
Right.
issue. But yes, correct, Your
You're
Honor.
not withdrawing your waiver.
Not withdrawing the waiver on the timeliness
You're
issue.
sticking with the waiver.
Sticking with the waiver.
Could I come back to the question, because I struggle with what Riley's telling us and what it's not telling us. In terms, the first part of the case, has this discussion, and it pretty clearly limits its holding, to the fact that the FARO is the final order, and that withholding only proceedings don't disturb removal. But Judge Harris is right, it talks about in that section 4 right before it some kind of practical things. And it's not clear to me what those mean. It sounds like Judge Harris thinks that means you can file a challenge to the order of removal without any basis to do so and that allows you to then later challenge CAP. That, I don't disagree that that's not what it's saying, but it doesn't say that as explicitly to me as, you know, maybe it does to others. So how do we read that section before, right, before the holding? Is it dicta that's not binding? Is it something, what do we do with it?
Well, Your Honor, I would say that you don't need to decide the precise parameters of what that means in this case because petitioner never challenged the
Well,
Pharaoh.
they have a petition to amend, and you're not backing off the timing of that. So, you know, if that does mean that you can file a fake or a protective petition, they're maybe trying to do that. So maybe we do have to figure it out, or, yeah, help me with that.
Well-
Why am I wrong there?
But I would like to take a step back and address the motion to amend and why the government opposed the motion to amend, is that there are no cases which have ever permitted an amendment to a petition for review challenging an immigration decision to raise a new challenge to a new agency decision, particularly at this stage in
What
the
if they did,
litigation.
okay, let's assume there's some technical reason where there's no case that allows it. What if tomorrow they filed a petition to review, a petition to review the order of removal and didn't say anything substantively about it? So it's not an amendment, it's not after the fact, but they filed a petition. You've already said you're not gonna hold them to the 30 days, so now we got a petition for removal.
And I think that would be different because that would be a
Of course
new
it's different,
petition
but
for
I'm
review.
trying to figure, it's still, it's procedurally different, but it causes us to, I think, figure out whether a challenge to the removal order in name only that doesn't bring any actual challenge is permissible after Riley.
And I believe, I may be incorrect, but I believe that issue is pending before this court in Martinez, after Martinez was sent back. And the government did file a motion to dismiss the second petition for review. In that case, challenging the reinstatement order on the grounds that the government, that would be a new petition for review and timeliness was not waived in that
Yeah, but
case.
I mean, I'm trying to get you to answer the question of whether or not a meritless petition to review a removal order is something that can create jurisdiction under Riley for a CAT decision later.
There is a possibility that it could,
What's
yes,
the
Your Honor.
government's position?
The government's position is that that is not squarely before the court here, and that is something to be decided in future
What if I think
cases.
the petition to amend, or the motion to amend that Riley has filed puts that squarely before the court, and we gotta decide it? Assume I think that, or assume hypothetically our court thinks that. What's the government's view?
That Riley does not contemplate that procedure so broadly that you could file what is essentially an empty petition for review, not challenging any merits of that final order of removal.
Can I ask you the same question I asked your colleague? How many people, it does seem that all the jurisdictional arguments here are only going to be relevant as to the class of people who have a waiver of this time bar, because otherwise everybody knows from Riley that you have to file an appeal from the FARO, and I understand we may have a different view as to whether that can be kind of a purely protective appeal or whether you actually have to come up with some ground. But from now on, everyone's going to appeal the FARO. So how many people are we talking about? What is the big deal here?
The government's position is that it's not a large group of people because it's going to be people whose petitions were pending and stayed during Riley, and then the government waived the timely.
Right, so is it like a
This
handful
issue.
of people? What is the big deal? Why don't you, we're just talking about a few people.
not talking about a large number of people.
What-
Do you have,
what's
like,
large
a rough-
mean?
A rough sense, yeah, like
Yeah, what does
more or
large
less
mean?
than 10.
300? Somebody said 300 already.
No, that's how many people in deferral only. How many people have a time waiver from the last administration?
Over all the circuits, less than 100, I would guess.
Okay.
And so then
That's a guess?
that's a guess, yes, Your Honor.
So you don't know?
No, I don't know exactly.
I don't know is also a good answer when you don't know.
I don't know, Your Honor, based on the
But
information.
your guess, your best guess, it's less than 100.
Yes, Your Honor. And so then following petitioner's position on jurisdiction, it would create a framework where a challenge to a final order of removal is not required, which is not contemplated by the statutes governing judicial review of CAT claims. And Nasrallah makes clear that there are multiple statutes that govern review of CAT orders. It is not only A4, 1252A4, but also 1252A.
What does A4 do in your view? Does it provide jurisdiction? Does it do something else? Tell me what you think A4 does.
That it's not an independent grant of jurisdiction, but it permits an alien to bring a CAT claim under 242. And FARA Section 2242D, which is also one of the provisions, makes clear that a CAT claim can only be brought as part of the review of a final order of removal pursuant to Section 242 of the INA. And then,
You said it, A4, if I understood you, I may have misunderstood you, permits someone to bring a CAT claim?
yes, Your Honor.
I read it differently. I mean, it looks to me like it's talking about the judicial review of a CAT claim.
That's correct, Your Honor,
Okay.
to bring a CAT claim before the Court of Appeals pursuant to a petition for review,
Okay.
as opposed to habeas review in district court.
But, I mean, that could mean a couple things. It could be, it provides jurisdiction to the Court of Appeals to review it. Or it could mean this gives direction to, if there is a review and if there is jurisdiction, to where it should be.
Correct, Your Honor, and
It sounds like you think it means jurisdiction in some way.
it means what may be brought before the courts of appeals and how those claims may be brought. Page 517 of Nasrallah, the first sentence under Section A, states that it describes, quote, 3 interlocking statutes that provide for judicial review of final orders of removal and CAT orders. And so the Supreme Court in Nasrallah was looking at the interplay between all of these statutes, and then in Riley, in the Thomas concurrence, in addition to looking at Nasrallah and Guzman Chavez, and now Riley, that's the progression here.
Counsel, I understand the jurisdictional argument. When I read Riley, it does seem it's sort of like an unusual and kind of pregnant silence by the majority in response to Justice Thomas's concurrence. There's not even like the usual sort of pro forma, like, oh, our colleague here has raised this jurisdictional question, but we, of course, leave that to the Fourth Circuit on remand. Do I read anything into the kind of just like complete stony silence in response to that concurrence?
I don't believe you can read anything in that because there was also no explicit rejection of,
It seemed unusual to me that there was not even a reference to it, and it can't be like party presentation because it's a whole jurisdictional question. It just seemed, but you think just read nothing into it. I'm genuinely puzzled as to what happened here.
and there is no acknowledgement of it one way or the other as an endorsement or a rejection of it.
And wouldn't it also be, this is also reading tea leaves, so I don't have any greater answer on that issue or the one I'm saying, but if the majority opinion is suggesting the way to do this is, meritless challenges to review orders. That would seem to foreclose Justice Thomas's view, and he's concurring in whole in the opinion. So this is a bit of an enigma for me, too.
That's correct, Your Honor, but also in the majority opinion, when they're talking about these different options in these cases, there's nothing that said there's, any kind of independent grant of jurisdiction over CAT claims absent a final order of removal, which would kind of address Justice Thomas's concurrence. So as you said, that it would be reading tea leaves.
Could you, I may have cut you off. Are you
No,
through with that answer?
yes.
Your colleague said, I'm moving to the merits.
Yes, Your Honor.
Your colleague says that the Board of Immigration's Appeals has improperly reweighed the evidence. What's your position about whether the Board of Appeals has acted improperly or not?
Here, the board properly reviewed the immigration judge's decision for clear error. It pointed out several areas where the immigration judge clearly erred in his factual findings. And both this court in Turkson and the Supreme Court in Ming Dai recognize that the board can override an immigration judge's factual findings. And here, the immigration judge found that evidence corroborated that Don murdered petitioner's cousin.
Can they reject a credibility finding?
Can the board reject the board did not reject.
Can they? I ask you if they can reject a credibility finding.
Yes, Your Honor, the board can reject.
So the IJ can rule the witness is credible, and the board can say the witness is not credible.
That's correct, Your Honor. I believe that happened in one of the more recent cases from this court.
Even though the IJ is the only one who's heard the witness.
That's correct, Your Honor. But here, the board.
Now that's different than normal trials situations that we deal with. You know that, don't you?
Yes, Your Honor. And here, the board explicitly declined to disturb the immigration judge's credibility finding.
What's the I'm sorry, Judge.
I'm sorry. No, I was going to ask that, but you answered before I.
So we kind of batted this around a little bit earlier. So it's kind of odd when you're not challenging the credibility, but you are coming to different conclusions about, that's not you, the board is coming to different conclusions about the evidence and what it shows, and finding that the immigration judge's findings about the evidence were not supported by the record. When you don't disturb credibility, you at least have to, it seems like an implication of that is that the record shows Mr. Riley believed he would be murdered. What do we do with a unchallenged credibility finding? How can you have that and still have the decision it made about the factual matters?
Precisely for the reason that you stated, Your Honor. Petitioner may believe these things are true, but that does not necessarily satisfy his burden of proof. That's what the Supreme Court said in Ming Dai. Petitioner's credible testimony or his belief about these things is a separate issue from his burden of proof. And here, the immigration judge specifically said that there was evidence that supported petitioner's belief that Don murdered his cousins and was responsible for the threats. But in the affidavits from family members, there's nothing showing that Don was responsible for the murders or the threats. The stepfather even said, we don't know who is making these threats. So it's, I'm sorry.
I'm sorry, on the murders, the immigration judge is actually really clear. There's this gap in the evidence, or I shouldn't say it, but there is a gap because he wasn't there when his cousins were killed. So even though he believes it was Don, he does not have firsthand knowledge. And so the IJ during the hearing really pushes him on this. And he does give this very lengthy answer about I know that's who killed my cousins, because that's how this works. This is a terror campaign. The Don is terrorizing the neighborhood, and it only works if everybody knows who did it. So everybody knows who did it. They brag about it. That's how this thing works. And if the IJ finds that credible, and the BIA also finds it credible, I guess I'm not seeing, like, maybe it's a close question whether that's enough to fill the gap, but I don't see how the IJ was clearly erroneous in finding, okay, that answers the question, that fills the gap.
Well, on page 30 of the immigration judge's decision, it's around the middle of that page, the immigration judge says, there's a letter from family members that also identify Andrew Hamilton as being influential in the neighborhood and having been the source of various threats. There is also corroboration of the two cousins who were killed. And then that's when it talks about how the applicant filled in the gap. But the letter from family members do not
To one
identify.
side, the letter from, okay, so you think, the BIA doesn't say this, I don't think, but the big clear error the IJ made said that the letters about the threats say that the threats are coming from Don.
And saying that there was evidence in the record to corroborate petitioner's testimony, petitioner's belief. And there's no specific evidence in the record tying Don to the murders or to the threats
I just
against.
gave you the evidence that the IJ credited tying him to the murders, which is, that's how this works. The Don is terrorizing the neighborhood. For that to work, everyone needs to know who committed the murders, so everybody knew because they brag about it. That's the evidence.
If I may, Your Honor.
You go ahead, long as you get questions.
Thank
just Go right along.
And the board is talking about how the evidence discussing the murders doesn't mention Don. And so, yes, the immigration judge pointed to petitioner's testimony, and the board is saying that
But
that's petitioner's.
Why wouldn't, okay, accepting that, if we just have the petitioner's testimony, maybe it's not corroborated, but we have the petitioner's testimony, is that enough evidence to overcome the limitations on what the board can do?
The board could still find in that situation that the petitioner's belief was not sufficient to meet his burden of proof, and that's where.
But let me just make sure I want to make sure my question is precise enough. Certainly people could view that evidence from Riley as insufficient, but if the immigration judge is the corroboration necessary for the immigration judge to satisfy the clearly erroneous standard?
For the board.
Yeah, for the board to be, so if the board's correct in saying the corroborating evidence is, not corroborating because it's not, specific as to this particular person, do we get to look at just Mr. Riley's testimony itself?
Does this court get to look at Mr. Riley's?
Is the fact that Mr. Riley said that mean it's not clearly erroneous and therefore the board can't come to a different conclusion?
No, because the board can look at the immigration judge's fact findings under the clearly erroneous standard, and that's what the board did here, and it reached a different conclusion. A 3-judge panel of the board reached a different conclusion, and this court would have to find that the record compels reversal.
But I may just be repeating Judge Quattlebaum's question. I hear you when you say the board looked at the evidence and it reached a different conclusion, and that's actually what it looks like to me too. Like, they looked at the evidence and they came out differently than the IJ, but that's not the same as the board explaining why the IJ's conclusion was clearly erroneous in that it's like implausible, illogical, can't be reconciled with the record. Like, it does really read to me like they're just saying, oh, we see it differently. Like, we weigh the evidence differently, but that's not enough, right?
And on page 5 at the top of the board's decision, the board engages with the evidence. It considers petitioner's testimony and also the affidavit. So it wasn't just saying we just don't agree. It was looking at the entirety of the record evidence in this case.
But they reweighed the evidence.
They did not reweigh the evidence. They reviewed the IJ's factual findings for clear error. And so the evidence clearly does not say what the immigration judge said it did, particularly with who was responsible for the threats against petitioner.
I'm sorry, I know can I just, one last question. Why does it matter, sorry, just kind of by the way, why does it matter who is responsible for the threats? If we know someone, let's just assume the family affidavits are credible, so someone is threatening to kill him the second he gets back home. So does it matter why? I know for asylum and for withholding, we really care why. It has to be, a particular social group and you need the nexus. But for torture, it really doesn't matter. If he's going to be killed when he gets back, why isn't that sufficient?
The why, the on account of prong, you're correct, Your Honor, does not
Right.
apply
So
in
who
CAT.
cares why? Who
cases.
cares if it's Dom? Someone is threatening to kill him. They seem like pretty credible threats as described by the family. And you do have the mother's affidavit saying that when she tried to go to the police with this, they did not just say, as the BIA says, well, he's not in the country, there's nothing we can do. They went on what she calls a rant about how they're not in the business of protecting criminal deportees. That's not what they do. So I'm not sure why the why matters so much here.
And the why matters here because it's petitioner's burden to show a particularized threat of torture
Well, it's
by
his
the
name. They're all saying he's the guy we're going to kill.
by the government or with its
Right,
acquiescence.
and the acquiescence comes from the mother's affidavit saying the police literally say we don't protect criminal deportees.
And petitioner's claim was based on his testimony that Don was a former police officer, and so the police wouldn't protect him. So the government's position is that the why and the who does matter in this case because that's all part of his claim here.
But I don't, I guess I just want to, I'm sorry, I'll let you go in 1 second, just maybe one more chance. We credit him. He believes that Don is the source of the threats. That's why he's testifying the way he does, and we're all agreeing, we're crediting that. But why does it matter if he's wrong? If there are these credible death threats, and I guess I just want you to assume for a minute the mother's affidavit suffices for acquiescence. Does it matter if he's wrong about who is threatening to kill him when he gets back?
And I believe it does matter, Your Honor, because it kind of explains this whole big picture of why anyone would be targeting him. If it was just random death threats, I don't think anyone would have granted CAT. There is the case law that says, general gang violence is not sufficient.
But it's not generalized. The threats are against him in particular. There's no particularity problem with these threats.
But if we don't know why.
Who cares? Like life is funny sometimes, like for whatever reason, I'm sorry, I should.
No, and I don't believe there's ever been a case from this court that just says just receiving threats is enough to meet the very heavy burden of establishing.
We have so many cases saying a death threat period is sufficient.
But there is more information, more background information presented. If there are no further questions,
Sorry.
Thanks so much.
thank you.
Ms. Professor?
Thank you. Just 3 quick points on rebuttal. Petitioner's testimony is not that he thinks Don will have him killed, or that he predicts that Don will have him killed, or that he's worried Don will have him killed. It's that he knows Don will have him killed. The immigration judge found him credible on that point and credited his testimony and found that Don will have him killed. Based on the record, petitioner's testimony, that it's calling petitioner's testimony speculative, is rejecting the immigration judge's credibility determination. Second, this court recently re-emphasized that the BIA may not cherry-pick evidence from the record in supporting its contrary view of the evidence. Doing so is an abuse of discretion, and that is reversible error. Third, petitioner, with his motion to amend, is not seeking review of a new agency decision. We are fixing form. At the time of filing, everyone understood that petitioner was seeking review of his final order of removal, and the government repeatedly characterized it as such. Thank you.
Thank you very much. Good to have you all here. We're going to come down and greet counsel, and then I'm going to exercise my discretion and take a brief break.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
You may be seated. In our next case, United States versus Bland, Mr. Mancini, good to have you with us, sir.
Thank you. Good morning, and may it please the court. Sam Mancina on behalf of the appellate Marcus Bland. The police violated Mr. Bland's Fourth Amendment rights by seizing him without reasonable suspicion that he was unlawfully carrying a concealed weapon. I'd like to start with the seizure and when it occurred, and then move to reasonable suspicion. The officers seized Mr. Bland when they approached him in the middle of the night while he was sitting in a car parked in front of a 7-Eleven convenience store
If that's, I appreciate that's your position. If the district court's determination of when there's a seizure, just hypothetically, if we agreed with that, do you question that there was reasonable suspicion at the time he grabbed Mr. Bland's arm?
No, we don't.
So everything depends on when there was a seizure from your perspective?
Exactly right.
Okay.
Exactly right. Yep. We argue that the seizure occurred before he grabbed the arm, when the
You
officer.
don't have an alternative argument that even when he grabbed his arm, there was a problem. So this is all about when seizure occurred from your perspective, right?
Yes, Your Honor, yes.
Okay, thank you.
Yep, and the seizure occurred before he
So
grabbed the arm.
I'm sorry, can I just ask you, and there was reasonable suspicion when the officer grabbed the arm of what exactly?
At that point, I think the officer had reasonable suspicion that Mr. Bland was attempting to assault at that point by reaching for the weapon. At that point, I still don't think there was evidence that the officer was, or I'm sorry, that there was evidence that Mr. Bland did not have a permit and was violating the concealed carry permit. But by reaching for the firearm at that point, the officer was within his rights to execute a Terry stop because of the fear maybe of an assault or something. But before that point, the seizure had actually occurred before that point because the officers had made a show of authority by stopping, or by approaching Mr. Bland, the officer who questioned him, Officer Goodnight.
Maybe by approaching the vehicle?
Yeah, approaching the vehicle. He walked up to the passenger door where Mr. Bland was, shined a flashlight in his face, ordered him or instructed him to roll down the window, and then asked him if he had a gun. And at that point, Mr. Bland was no reasonable person in Mr. Bland's position would have felt free to leave or ignore the officer's show of
So
authority.
the seizure just, because these are sort of like second-by-second cases, but the seizure occurs when he asks the question or when he tells him to roll down the window?
I think it's when he asked the question at that point, because when he tells him to roll down the window, then Mr. Bland complies with that, submitting to the show of authority. And
When
then
was the question asked?
the question was asked immediately after he rolled down the window, and right
It
when
was
the
after he
officer.
rolled down the window?
Yes, after. And he,
Did he ask the question if you still have the gun immediately, or did he, I can't remember this exactly, but it seemed like he started to and said, "You're leaning on it." And so he really never asked the question until Bland leaned over. And it's almost like you never get to the question because of the conduct. I mean, this is all within seconds. Maybe I'm misremembering that. Certainly you know the record better than me, but it seemed like he didn't finally say, "We have an undercover officer who's reported a gun, do you still have it?" until after he had leaned over and, may have been trying to cover up or hide the fact that he had a gun.
yeah, so it does happen in a matter of seconds. Once he rolls down the window, the officer says, "We just had an undercover officer in here. You're actually leaning on it. Do you still have your gun?" And that's all sort of one sentence. The leaning over, though, the district court explicitly found that, or she did not credit that testimony that he was making any sort of blading or covering motion. He was just leaning closer to listen to the officer, or that was an equally possible. That's equally plausible. That's what he was doing. He was just leaning
So
over.
everything's okay, no seizure until he says, "Do you still have the gun?"
Yes, yeah, at that point, because I think the question, "Do you still have the gun?" not only is that sort of an accusatory, investigatory question, but it shows that they're really targeting Mr. Bland. I mean, they pull into the parking lot and immediately walk right up to
Can I ask you about
him.
that? Because it does, I know the law that says if you ask these accusatory questions, usually, we have said usually the police start with some pleasantries and then they say, "Can I ask you a question?" So the first thing out of their mouth isn't an accusation. But it does seem to me that, I understand you can read this as being kind of accusatory, but it's also kind of a safety question, right? If you're going to stop someone in a parking lot in the middle of the night, and we've said that's fine, that's still a consensual encounter, it does seem like maybe actually the first thing you'd want to know, if you know that the person was armed recently, is first question, are there any guns here?
That's true, but I think in this situation, by talking about the undercover officer, it's clear that they're looking into Mr. Bland. This isn't just some sort of routine encounter. "Hey, do you have a gun on you? What's going on around here?" It's an undercover officer saw you with a gun. Do you still have it? And so I think they're making it clear, we're investigating you particularly.
Well, we certainly that we want to talk to you in particular. I agree with that.
Yeah.
But I'm not sure I'm seeing the accusation. The particularized part, yes, but, I mean, in your own position is having a concealed weapon, like, that's not an accusation. If you have a permit, it's fine.
That's true. I think it's somewhat similar to the situation in Jones where that's the one where they sort of blocked the car into the alley, and they went up to the driver and they asked him to lift up his shirt so that they could search. And in that case, they also sort of said, hey, how's it going? Can you lift up your shirt? So just because it's, the question is or the statement is formed as a question, or there might be some pleasantries, doesn't mean there isn't a seizure here. And I think the question or the targeting of Mr. Bland is just one factor to look at. You also have the flashlight, the time of day, which is in the middle of the night, and the fact that the officers were in uniform, were armed, where they parked their vehicles. I understand that the district court found that the car wasn't blocked in, but I still think them driving into the parking lot, sort of flanking his vehicle and then immediately proceeding to him.
Is there any evidence that Mr. Bland knew the locations of the vehicles?
I think there's no direct evidence in the record. The Officer Goodnight, who's the one who goes up and questions him, says that he made eye contact with him in the side view mirror or the rear view mirror, and Officer Goodnight was parked directly behind the car that Mr. Bland was in. So it's reasonable to think that he could have seen the cars behind him, but there wasn't a finding one way or the other.
I'm sorry to cut you off
I'm sorry.
after asking the question, but does that I mean, do you agree if there's things that might cause someone to not be free to leave that they don't know about, those don't count?
I would agree with that because I think it's from the perspective of a reasonable person in the defendant's
But
shoes.
how do we, it just feel, I mean, just looking at the video and there's no sirens, I mean, I don't get in, really wasn't discussed a lot by the district court, but just looking at it myself, I mean, there's just no indication that it's at least obvious that he would see the location of the cars.
That might be true, but I guess even if he didn't know the location of the cars, I think once he sees the officer come up, and I think the real key fact here is where Officer Goodnight positioned himself when he was talking to him by standing right next to the door and blocking Mr. Bland's ability to exit.
But aren't you there? I mean, that's interesting, and I hear you. I mean, it's true. You'd either have to hop over the console, which, that's probably not the best idea if a policeman's talking to you, even if in theory you have some legal right to do it. Or you have to get out, you have to, arguably he's got to move out of the way or something like that. But I mean, I think our law says you don't, if you're still in a non-seizure situation, presumably you can say, I'm not going to talk to you. And does your position kind of mean that if someone happens to be in a car in the passenger seat, if coming up there means he's seized, haven't you eliminated this ability to have a voluntary conversation?
No, I don't think every time the police go up to talk to someone in a parked car, that they're initiating a seizure. Here, the distinguishing factor, I think, is that there was no driver in the car. So there was no way to drive away. A lot of the cases...
So the fact there's no driver in there is on your side, then, you're saying?
Yes, I would say that, because if there were a driver, or if Mr. Bland were in the driver's seat, he could simply drive away. I mean, that's Lewis and
There was
some of the
nobody
cases.
under the wheel here.
There was no one on the wheel. The driver was inside the 7-Eleven, I think, buying lottery tickets.
Drive away, I mean, driving away is kind of, even though if physically there's room for him to drive away and legally he could drive away, it's kind of nuts to say you're going to drive away and everything's going to be okay. And but if your position is that's okay, why couldn't he just roll up the window and say, I don't want to talk to you, officer?
Because I think at that point, the officer, I think you have to think of it from Mr. Bland's perspective. It's the middle of the night. There's an officer literally inches away from your face with a flashlight asking if you have a gun, and he directed you to roll down the window,
But you're
and he
saying
complied
if
with
that was
that.
on the passenger side, he could drive away and we wouldn't have, he'd be free to leave. It's odd to me that you think that would make him you know, not seized, but in the passenger side he is. I mean, I don't mean to be, you know, just keep beating a dead horse, but that seems odd to me, that you think he could drive away in a parking lot with a police officer, you know, approaching him and shining a flashlight in you, if that's your, and then, but not refuse to talk and not roll up his window.
I think that's the key difference, though, is that you have the ability to get away. There's a way to leave.
Counsel, isn't that just the, forgetting the name, but the case with the bus, is it Bostic? Where, you know, you're on a bus, you don't want to get off the bus, you've got somewhere to go, you don't want to be standing on the side of the road. And the Supreme Court said, even so, you haven't been seized because it's not the police officer's fault that you can't just get off the bus. And we ask a different question, which is not, would you be able to leave, but just, would you be able to terminate the conversation? Just stop talking to the police officer. So I guess I'm not seeing why it matters that there's not a driver who could drive the car away. That's just Bostic. There's no realistic possibility you can get off the bus because you don't want to leave.
I think there's actually two factors about Bostic that make it different. First, it was in a busy public place with a lot of people around. I think there's somewhat strength in numbers. You might feel more comfortable, you know, refusing to talk to the police if other people aren't doing it. It also seems like a routine inspection where they're asking multiple people, not just you and targeting you. The other fact about Bostic is the officers informed the passengers that they could say no, that they did not have to consent to a search of their bags. And we don't have that here. I think if the officer had said, you don't have to talk to me or something like that, that's not required. But if you had that factor, that might change the calculus here. And I think in Drayton, which is the other bus case the court decided later, one of the factors they looked at was that the officer started in the back of the bus and left the aisle open and came forward, leaving the ability for the passengers to exit. And here, that's the problem. There's nowhere for Mr. Bland to go. He can't exit the vehicle. He can't drive away. There's really no escape route. And when you have an officer inches from your face asking about a gun with a flashlight, I don't think it would be reasonable to just roll up the window and ignore him at that point.
What about the issue that there's, assume I think, you know, Weaver's testimony is a credible source of information, and that there's evidence that Mr. Bland had a gun that was exposed, went out, came back, and it was no longer exposed but was concealed. Or maybe just it was concealed but visible, you know, in his clothes. You know, do the police officers not have the ability to ask him if he has a permit?
They could ask him if he has a permit if it was a consensual encounter, I think. If they seize him, or they can't initiate a Terry stop based just on the fact that he has a concealed weapon.
So, okay.
That's Virginia law. You're talking about the concealed permit is an affirmative defense or something under the Virginia statute.
It is an affirmative defense, but I don't think that makes a difference for the Fourth Amendment purposes.
That doesn't have anything to do with it. Or does it?
No, I think the officers still need some evidence of illegality. They have to know that you're doing something unlawful, and I think that's why the driving cases are so helpful. You can't just stop someone on the highway to spot check if they have a license or not, because you
And
can't.
as it turned out, he had a felony conviction.
It turns out he had a felony conviction, but here the officers had never had any
Did you represent him at the earlier proceedings?
I did not represent him in the trial court. Someone else in my office did.
You're the public defender's office.
Yeah, the public defender's office.
So,
You all had instead of a conditional plea, you had a stipulated bench trial.
Yes.
Is that something you do a lot?
I think we do it sometimes
I've
to
never
help.
heard of that before. I don't think I didn't remember it anyway.
I
I've seen
think
a lot of conditional pleas, but here you had a bench trial and stipulated to the facts.
Yes, exactly. I think to preserve the suppression and the Second Amendment issue.
To preserve the issue.
Exactly, because we're not allowed, or I wasn't representing Mr. Bland below. I can't speak to the
Yeah,
discussions.
but you're the only lawyer we got here, so you
Yes.
have to answer the question.
Yeah, no, exactly. I don't know exactly why a conditional plea couldn't be reached, but sometimes when that doesn't happen, they end up doing a stipulated bench trial to preserve the pretrial issues for appeal.
just to follow up on the concealed weapon issue. So, as I understand your position, it's okay, an officer is permitted to ask an individual who they suspect may have a concealed weapon if they have a permit, but they must do so in a voluntary way, not in something that's a seizure?
Yeah, I could imagine a consensual, pedestrian encounter where you're out in the open, you're in public, and you're talking, and it comes up or something, and you say, do you have a permit? If the person volunteered that they had a gun, or you think they have, the officer thinks they have a gun, they could say, hey, do you have a permit for that? But I think once you can't initiate a Terry stop without knowing that without having some basis to believe they don't have a permit.
Do you think the district court cited the Pope and the Mayo case and another district court case called Morton? Do you just read those different, or do you think she was legally wrong in that?
I read Pope and Mayo differently, and I think in those cases, Mayo and Pope, there was evidence of illegality. In Mayo specifically, the defendant, as soon as he saw the officers, fled and tried to evade them. And then when they came up to him, he was behaving nervously. I think when police officers have evidence that this person they think he has a concealed weapon, and they're doing something, evasive or behaving nervously, you can then have reasonable suspicion that maybe they don't have a permit, that they're holding the gun unlawfully. But you need something more than just the knowledge of the gun. It's the gun plus something else.
What if you also know that, it's really, really hard to get these permits and very few people have them? I know that's not the facts here, as I understand it. We don't know anything about how many of these permits there are from the record, but what if the police officer testifies, look, I checked and Virginia's only given out 5 of these permits? I mean, then at that point, can't you assume, aren't you close enough to reasonable suspicion if you see someone with a concealed weapon that odds are they are not one of the 5 people in the state of Virginia with a permit?
Yes, I think that would be allowed, but the government would have to make that record with an officer below. This was addressed in the Feliciana case, which is the one about the commercial vehicle. There, the government argued that, well, there's just not a lot of commercial vehicle permits, but they hadn't introduced that evidence below. And so at that point, if the officer doesn't have any reason, if they don't have that evidence, they can't just stop people and check them.
But so your position, it sounded like it was a blanket position, that in all circumstances, reasonable suspicion that someone has a concealed weapon would not equate with reasonable suspicion of illegality. But now I'm hearing you say it actually sort of depends on the facts on the ground and what sort of a showing is made about those facts.
Yes, there's no per se rule. It's just, you need something more than the gun, whether that's evidence of the number of permits or some other indication of illegality like nervousness, evasive behavior, lying, something like that.
So why don't you think, this was the first question I asked you, that by the time he grabs his arm, you don't think there's reasonable suspicion that, and we're assuming now assume with me for a minute, that there's reasonable suspicion of a concealed weapon. It would seem to me that once you're asked if you have a gun and you kind of repeat the question and act a little bit weird and don't offer up to the police officer, yeah, I have a gun, but I also have a permit, by then you don't think there's reasonable suspicion that this person does not have a permit?
I think it's a close call. I don't know if I would agree with the description of Mr. Bland's behavior. I think he was just a little taken aback, took a moment, and then admitted he had a gun. He started reaching for his pocket, but there wasn't really time. It happened so fast, there wasn't really time for him to say he had a permit. It could have just slipped his mind. I mean, if you're confronted by the police, you might be nervous. You might be reaching for the permit, even though that wasn't the case here. I just think at that point, there might not been enough, but it's a close call. I'll reserve the remaining of my time for rebuttal. Thank you.
Thanks very much. You saved some time. Mr. Sawyers?
Good morning, Your Honors, and may it please the Court. Reed Sawyers for the United States. I want to start with what I think is a telling concession from my friend. Below and in the briefs, there were sort of 2 points put forward as when the seizure occurred, either when Bland's arm was grabbed, which is our position, or when the officer walked up to the car. That was my friend's position below and in the briefs. Today, he's changed positions to say it's when the officer asked about the gun. But by that point, even assuming you needed to negate the affirmative defense of the permit, which I'm happy to get to in a second, because Bland was leaning, because Bland was blading, and the officer believed that he was doing so to conceal a firearm, and doing so also implies that you don't have permission to conceal a firearm, the officer would have had reasonable suspicion at that point. There wasn't, to be clear, a ton of discussion about this below because that point wasn't put forward as when a potential seizure would have occurred, but viewing the evidence in the light most favorable to the government, the officer would have had reasonable suspicion at that point. It's true that the district court at JA 210 said she wasn't relying on the blading, but she found the leaning actually occurred as a factual matter, and the fact that the district court could think of an innocent explanation for that conduct does not mean on appeal and viewing the evidence in the light most favorable to the government, that does not suffice for reasonable suspicion were we required to negate the permit affirmative defense. Turning to the seizure argument, it seems like the one factor my friend is putting forward as most dispositive is the question about whether he had a firearm. As you, Judge Harris, noted, that's not a particularly accusatory question to begin with. And we have cases like Anyala, where officers literally told the defendant he matched the description of a murderer and asked whether he had a firearm. So if that wasn't sufficient to constitute a seizure in Anyala, telling someone you think they're a murderer, asking someone whether they still have a firearm is not sufficient here. Likewise, on the point about the officer being a foot or two away from the car, we have several driving cases where officers go up to a car. That's Lewis, that's Scott, that's General. And that's not sufficient. The mere fact that maybe it's temporarily harder for a second to get out of the car when an officer or even a random person is standing there, because you're able to ask the officer to step away, that doesn't count as a seizure. And while not cases about standing in front of a car specifically, I think Anyala and Weaver, which are cases about retention of a driver's license, which also in some sense temporarily prevent you from leaving, in those cases as well, the court said that doesn't suffice for a seizure because you're free to ask for them back. So I think the district court was absolutely correct in finding that Bland was not seized until the officer grabbed his arm. If the court has no questions about this seizure, I'm happy to turn to the issue about whether the officers needed to negate the permit affirmative defense. Although,
Yeah, I'm aware of a lot of our cases, and you've referred to some of them. Yeah, and you know, they're on the books, and you know, we owe them the proper precedential respect. But I mean, do you really think someone in Mr. Bland's position felt free to, you know, ask the officer to move out the way and say, "I just want to leave" when he pulls up? I mean, is that reasonable for us to conclude that an individual, you know, confronted with a police officer coming to them would really feel like that was something that they could do? I mean, maybe they have the legal right if you're a lawyer and know all that, but would a normal person think, "Hey, I can, you know, tell the officer I want to talk, step away. If they don't, I can climb over the, you know, the console in the car and just walk away"? I mean,
so just to quickly answer that last part first, the primary means we think a reasonable person would have terminated the encounter is by asking the officers to step aside. So you don't need to think, I mean, we do think it's reasonable. We have this Adonis Perry case where someone actually did that. But the primary means we think a reasonable person would have terminated the encounter is by asking the officers to step aside. To answer the main thrust of your question, I think we have to remember that the standard here from Bostick and Drayton is whether a reasonable, innocent person would feel free to terminate the encounter. And it's very important this court emphasized in McCoy that uncomfortable does not equal unconstitutional. In Weaver, this court emphasized that awkwardness is not sufficient. In the In another case, the Supreme Court emphasized that even something that's somewhat intimidating is not sufficient. So I agree that often when you're around the police, it might be uncomfortable. It might even be a little bit intimidating. It might be a little bit awkward. But that does not rise to the level of a seizure. And I think, again, to return to cases like Anyala, there you have 3 officers. You're telling the person he's literally suspected of murder. And this court has said that that doesn't suffice for a seizure. You have Scott, where the officers knocked on the window of the defendant's car door, and as he awoke and as he tried to exit the car, the officer actually closed the door on the defendant and told him to roll down the window. And if those do not suffice to constitute seizures, I don't think this case is anywhere close to those.
So when was the seizure here?
The seizure was when, it's at 52 seconds into the video, it's when the officer Goodnight grabbed Bland's arm because he was reaching for the firearm. And I think just...
You say reaching for the firearm, he was reaching for something.
Well, yes, but I actually think this is a very important point to make. This court has to view the evidence in the light most favorable to the government. Several times, both in the briefs and today, my friend made statements
But
that...
you're saying because, that we have to do that because there was a guilty verdict after a bench trial.
That comes from the denial of the motion to suppress rather than from the guilty verdict, but yes. And so just a couple of examples of that. I don't want to go through all of them, but my friend said the officer shined the flashlight in Mr. Bland's eyes. That's not the finding made by the district court. I don't think that's clearly supported by the video. I think the most important you were getting at, Judge Quattlebaum, is that there's no evidence in the record that Bland saw the cars come in or even saw the second officer, Officer Umstead, before the seizure occurred. The only testimony we have in the evidence is that right as Officer Goodnight was walking up to him, they made eye contact in the mirror, and that's at JA 160.
There's, the district court in describing what happened, and I can't remember this from the video. When I looked at it, it may have been there, and I just don't remember, but I appreciate your view. This is at like 2:09, 2:10, you know, and the court describes what happened as he says, this is Officer Goodnight, "Hi, sir, can you roll down your window?" Is that, and that's in quotes, is that what the video shows?
My understanding is that the testimony was, and I believe this was from the video, but I don't have perfect recollection of this, is that Officer Goodnight simultaneously made some sort of gesture, like roll down your window, please. And I believe there was testimony that he simultaneously told Bland to roll down the window. And then there was some very quick sort of introductions, like, "Hey man, how you doing?" from both of them. And then Officer Goodnight went into the question, like, "Hey, we had an undercover officer in here and you're actually leaning on it. Do you still have your firearm on you?" And I'm not purporting that those are exact quotes, to be clear, but something along those lines.
Yeah, so the district court, or the transcript, has the district court describing things and has quotes around it. So I don't know if the court said quote, but that, and what is quoted in the transcript is relatively similar to what you've just described. So, I mean, do you have a position of how that was happening? Was she quoting below what the video said, or was she, you know, essentially summarizing it, in her words?
So here's what I'll say. Yeah. I didn't go through the district court's description and compare it word for word. I thought it was, as a general matter, an accurate characterization, but if you're like picking up on some like 1 or 2 word difference, I can't countermand that because I didn't make that comparison.
I was really trying to get to the notion that there was a point about whether the initial, maybe I misunderstood your colleague's position, but to the extent there's an insinuation that the very first words out of the officer's mouth are, "Do you have a gun?" it appears like that's not what the court found.
Yeah, that's not what the court found. That's not what the video shows. And obviously my friend can talk for himself, but I don't think he's going to say that on reply. I think he'll acknowledge that there was some very quick small talk before the question about the gun.
Quick in time.
The entire from Walking up to the car to the seizure was about 12, 14 seconds, depending on how you count. So it was certainly very fast. And as my friend conceded, if this court finds that the seizure occurred either when the arm was grabbed or, as we just argued, when the question was asked, we think there's reasonable suspicion without needing to get into the second question about whether the government needs to negate the affirmative defense. I'm happy to discuss that secondary question if the court would like to, or I'm also happy to rest on my briefs if the court has no further questions.
Ooh, I would like to talk about it. It's just such an interesting question.
It is.
So your position is that everything turns on the way the statute is structured? It's because this is an affirmative defense?
So,
Yeah.
I don't want to say, like, structured can mean two things. Structured can mean you're doing a statutory interpretation to determine whether something's an affirmative defense or an element, or it can mean in the Feliciana sense. There, I think it's clear that the permit was an element, but we tried to argue in Feliciana that even though it appears the permit was an element there, something about the statutory structure being phrased as an exception, which isn't, a term in elements versus affirmative defense, allowed the court to infer that the defendant did not have a permit. So we are focused on structure as insofar as it means element versus affirmative defense. We are not making the argument rejected in Feliciana that even if something is an element, the way the statute is structured or written can allow you to infer that someone lacks a permit.
But I thought Feliciana's point was slightly broader than that it was, look, these statutes are written in all different kinds of ways, and surely, like, that can't be what matters, because what matters is sort of the facts on the ground. Like, is this a rare thing or not? What is the common sense, practical default assumption when you see a car on a road or when you see someone with a gun? But you read it more narrowly than that. You think Feliciana leaves room for the idea that, look, if it says right in the statute it's an affirmative defense, then that is per se not something the government has to deal with on reasonable suspicion.
Yes, and I went back and read the briefs in Feliciana and listened to the oral argument, and I don't think the phrase affirmative defense ever came up. So I think it was taken for granted there that it was an element. So nothing in the opinion itself clearly addresses the affirmative defense elements distinction, and there would be no reason to because it never came up. And this is a well-established distinction in U.S. law going back at least all the way to the Supreme Court case Collins from 1922, where the Supreme Court said that you don't need to address evidence of insanity. That was irrelevant to probable cause.
But it just seems to me that with most affirmative defenses, I mean, it also goes back for hundreds of years, maybe. Reasonable suspicion, probable cause, these are like factual common sense determinations. And the idea that, right, the government or the police don't need reasonable suspicion that you're not insane if they see you casing a bank, I mean, that corresponds to our reasonable common sense understanding that most people are not insane. Mostly if someone is casing a bank, they're not going to have an affirmative defense of insanity. But what if, like, everybody in Virginia is carrying one of these permits?
Well, I will answer that, but to quickly say something, I do think this issue is ultimately resolved by binding precedent, so I do think it's a really interesting question in the abstract, but I do want to say I think the clearest case on this is Cloud from 2021, where the court is clear that even though the officers in North Carolina, which has the identical scheme, did not know whether the defendant was in conformance with North Carolina's concealed carry statute, they had a reasonable suspicion. But to return to the thrust of Your Honor's question.
Just hypothetically, what if, I don't even know how many adults there are in Virginia, but let's assume or let's say in this county, there's, 200,000 adults, and the police get on the stand and they say, yeah, I know that there are 200,000 concealed carry permits in this county, but so what? It's an affirmative defense.
So I would say that if you look at all the courts of appeals have basically adopted this elements affirmative defense distinction as a general matter, and at least 5 other courts of appeals, in addition to this court, we've seen adopting this as regards.
So you would say, even if that police officer gets on the stand and says, I am aware that every adult in this county has a concealed carry permit, you would still have reasonable suspicion to stop someone if you knew they had a concealed
The
weapon.
exception to the rule is courts have said where it's I don't remember the exact phrasing, but where the officers know that the affirmative defense is satisfied. Courts have said that if the officers actually know, or a reasonable officer, because this is the Fourth Amendment and its objective standards, if a knew conclusively, that's the phrase I was looking for. If a reasonable officer would have known conclusively that an affirmative defense was satisfied, then they don't have reasonable suspicion or probable cause.
So what if it was 200,000 adults and there's 195,000 concealed carry permits in that county?
That's a very tough hypothetical, Your Honor, but we are going to stick to our position that this is the rule, that courts have distinguished between elements and affirmative defenses.
I think Judge Harris is advocating for mathematical analyses in the Fourth Amendment context.
And I know courts are very leery of mathematical analyses. I find them somewhat convincing, so it's hard to push back on Judge Harris, but I will bite the bullet on that hypothetical. If it's somewhat probable that someone had an affirmative defense, our frontline position would be that they don't need to negate it. Now, is that good law enforcement practice? Absolutely not. Would we encourage law enforcement to do that? Absolutely not. But from a Fourth Amendment perspective, I think the rule is clear that unless a reasonable officer would know that the affirmative defense is conclusively established, they don't need to negate it. But of course, this court does not have to reach that issue here because of the seizure point.
But that would be the only basis for, that's the only basis for if we felt the seizure occurred at the moment he approached the car, what you're just talking about with the concealed weapon, being the reasonable suspicion, that's all there is, right? There's not anything else?
Yes, Your Honor. In other cases, there's testimony like people who carry their firearms in their pocket, are not generally carrying lawfully in states where the concealed carry permit is an element. We concede that we do not have such testimony here. We do have the good faith argument. So even if this court were to look past Cloud and Black and the Virginia Supreme Court's Whitaker case coming to the same place, and say, take those en banc or something and say this was a Fourth Amendment violation, we do still think the officers at the very least relied in good faith on this court's authority and the Virginia Supreme Court's authority, permitting them to go up to someone they suspect of having a concealed weapon and engage in a Terry stop.
Does the sequence that Weaver observed, observing Mr. Bland first with maybe some of the gun visible, and then him leaving and coming back and it being concealed, does that matter?
Well, our primary position is that seeing the partially concealed weapon, seeing the 2 or 3 inches, was sufficient for Officer Weaver to have reasonable suspicion of a concealed weapon because the Virginia cases are clear.
So you think that's concealed enough?
But, as the district court explained, it was even more obviously concealed when Bland came back into the store with it fully concealed. And there's testimony at JA 154 from Officer Goodnight that Detective Weaver told Officer Goodnight there was still some weight in the pocket.
So, but is that still getting at whether it was concealed as opposed to getting at the fact that he was trying to hide it?
So there's no testimony in the record that Bland recognized Officer Weaver as a detective. So obviously the court has to view inferences in the light most favorable to the government, but I don't think we ever advanced an argument that was, you can infer from Bland going out to the car and then coming back with it fully zipped up, that was him trying to hide it, which in turn showed he didn't have a concealed carry permit.
That's also a little inconsistent with the concession that there was no suspicious activity besides a concealed weapon.
The officers didn't rely on his return as indicative of suspicion. Bland lacked a permit because they've obviously been trained on Virginia law, which is that you don't need suspicion to conduct a Terry stop on this basis. If the court has no further questions, we urge the court to affirm. Thank you.
Thank you very much, sir. Mr. Mancini?
Thank you. I'd like to make a few quick points on the seizure issue and reasonable suspicion. On the seizure, first, I'd like to start with the cases. My friend on the other side cited Anala and Scott. Anala is a pedestrian case where they walked up to someone who was free to move about, walk back and forth. This case is much different. Mr. Bland was trapped in the car with nowhere to move. I mean, if he tried to open the door, he would have hit Officer Goodnight and could have been charged with assault of an officer. And I think this case is similar to Cloud, which has both a seizure and a reasonable suspicion component. On the seizure component in Cloud, 2 officers were
And the
pointing.
point is you're trying to make the seizure earlier?
Yes, the seizure occurred earlier, and I think,
And when did it occur in your view?
I think it occurred when the officer asked if he had a gun in his pocket at that point. And at Cloud, it was a similar facts where the officers were pointing their flashlights at a vehicle with occupants. They thought there might have been a concealed weapon inside.
I know you mentioned you weren't handling this below, and I hope this doesn't sound like I'm saying someone did something wrong. But is there an issue, did you advance, or did Mr. Bland advance that argument that the seizure occurred at the time of the question below?
Yeah, I mean, I don't know the precise wording, but it was when the officer approached and started talking to him, before the grab. It was
Yeah.
clear.
Those are different things, aren't they? They may be, I mean, one position could be just merely walking up there is a seizure. Just the presence of the officer coming up and approaching him. Another position could be that's not, but when you ask a question about a gun, there's a seizure. I know this is relatively short in time, but those are different positions. And what I'm just trying to figure out, without deciding what difference it might ultimately make, is whether, now, if you're saying it was when the question was asked, is that different from what was argued below?
I don't think so. Again, I'd have to go back and look exactly at the wording of the motion to suppress. I think a distinction can be made between when Mr. Bland rolled down the window and then seconds later when the officer asked, do you still have the firearm? To be honest, I think the question just adds to it. There actually might be a seizure when he rolls down the window and submits to the show of authority, but then asking the question about the gun on top of that, I think just confirms the show of authority here.
And you're saying Judge Hayes got it wrong. Is that what you're saying?
The judge below?
Yes. That's Judge Hayes.
Yes, Judge Haynes, well, she found that the seizure.
What's the error she made that you're focused on?
That she concluded that the seizure occurred not until the officer reached in and grabbed his arm.
How many seconds is there between what you said the seizure occurred and when she said the seizure occurred?
I haven't timed it exactly, but I would say somewhere between 3 to 5 seconds.
3 and 5 seconds.
Yeah. But I think in that time, there's a significant difference. Obviously, Mr. Bland started reaching for the firearm. Before then, the only thing the officers knew was that he had a firearm, nothing else. They didn't have any suspicious movements or anything like that. But I think going back to my point about Cloud, in that case, the officers were standing back from a car, pointing their flashlights and asking if they had guns or drugs inside the car. And this court concluded that that was a seizure. So this case isn't different. Moving to reasonable suspicion, I don't agree that the Cloud reasonable suspicion analysis decides this issue. In Cloud, there were some different facts. Most notably, the officers had testified that the parking lot they were in was a high crime area. We don't have that fact here. And in fact, the officers in Cloud had found guns.
There were other facts in Cloud, I agree, and the court could have reasoned the issue that way in Cloud, said under these circumstances, the concealed weapon, reasonable suspicion of a concealed weapon equated to reasonable suspicion of illegality. But that's not what we said. We just said reasonable suspicion of a concealed weapon is potential illegality, and that is good enough for reasonable suspicion.
I think in that case, they said that they didn't know exactly whether he had a permit or not, but I think given the other factors, the officers had reasonable suspicion.
That's not what we said. We said potential. We used the word potential. The fact that you have a concealed weapon means you are potentially illegally carrying a weapon, and that's good enough for reasonable suspicion. We dispense with the whole thing in like 2 sentences. I mean, I don't know how much this issue, I did not go back and look at the briefs, and I don't know how much this issue was briefed and argued and focused on in Cloud, but just the language of the opinion, I think, is pretty conclusive in the way it talks about this.
Well, I would say, I guess I read the opinion slightly differently because there was a longer explanation of all, the court actually went through some of the facts, including the high crime area, there were minors in the car, which I think matters, and then said then used the word potential, and I think when you have a high crime area, when you have maybe a violation of a different
So
firearm
you feel like they
statute.
were sort of incorporating that discussion?
Exactly, and I think that at that point, they might have reasonable suspicion that there was a potential concealed weapons violation, but the fact of the gun itself is not enough on its own, and that's all we have here. And just one last quick point on the affirmative defense point. Some driver's license statutes also make having a license or a permit an affirmative defense. So if we follow the government's position in this case, then that would overturn Delaware v. Prus, the Supreme Court's
Which I remember coming
precedent.
up at oral argument in Feliciano.
Yeah, exactly. Just because the permit is an affirmative defense does not relieve the officers of their obligation to have reasonable suspicion that the person does not have a permit or is doing something illegal. If there are no further questions, I'll rest my case. Thank you.
Thank you very much, sir. We appreciate you. And we'll come down and re-counsel and then call the next case. Our final case today is United States versus O'Toole. Mr. Turpening,
Yes, Your Honor, thank you.
good to see you.
Good to see you, Judge.
Good to have you here.
Thank you. May it please the court, Will Turpening for appellant Jonathan O'Toole. This case has been thoroughly briefed. With the court's permission, I would suggest that we focus our discussion today on what I think are the two most interesting issues. The issue where the government destroyed two different types of exculpatory evidence. And then the second issue I'd like to focus on after that, with the court's permission, is whether the district court should have dismissed count 3, which is the use of a firearm in furtherance of a felony, specifically the possession with intent to distribute felony that occurred on November 19th, on the basis that there was insufficient evidence that a firearm was used in furtherance of that crime. One preliminary point that I'd like to make, of course, in this case, is the thinness, just to point out the weakness of the evidence in general against Mr. O'Toole. The conspiracy component of this case, the conspiracy count, relied entirely on testimony from two seasoned professional drug dealers who implicated O'Toole, who was an indigent, homeless user, who was much less sophisticated in the drug business than they were, and who was a demonstrable consumer. And then the possession with intent to distribute count relied entirely on events that occurred on November 19th at a hotel near Charlotte, mostly relying on alleged drugs that were found in a hotel room that O'Toole was never in, or that there was no evidence that he was ever in other than testimony from one of the alleged co-conspirators, Mr. Boone. So to begin with the issue that the district court should have dismissed the indictment or suppressed all evidence related to the suspected methamphetamine because the government destroyed the suspected methamphetamine and its packaging.
What they destroyed was all methamphetamine?
Well, it destroyed all the methamphetamine that was seized at the hotel room on November 19th, and I would suggest even more importantly, it destroyed the packaging that methamphetamine came in.
Okay, but
And-
the only drug they destroyed was one meth.
That's correct, Judge. They destroyed approximately 500 grams of alleged methamphetamine.
And they admitted that they did it by mistake.
Well, I think that's an important issue, Judge. They admitted that they did it intentionally, and their position was they did it because they mixed up case numbers.
And Judge Cogburn agreed with him.
Judge Cogburn held it.
He so found that they didn't do it in bad faith.
He did make that finding, Your Honor. That's
Yes.
correct.
So you've got to get past that.
I do need to get past that. I would suggest that well, let me address that, Your Honor. I don't think that we need to show bad faith in this case under Youngblood and the cases interpreting it for two reasons. And this is where, with respect to, would the court mind if I grabbed a bottle of water very quickly? I have a little bit of dry mouth, I'm sorry.
Absolutely. Yeah.
Sorry about
Take
that.
your time.
With respect to the methamphetamine, the government had to use the methamphetamine to prove its case. And so our interpretation.
Why'd they have to use it? Could they just put on oral testimony that that's what it was?
Well, they had to use at least testimony about the methamphetamine
No,
to.
but they assumed they didn't have any drugs. They could have had testimony that they bought and used drugs.
That's correct, Your Honor, but our interpretation of the case law is that when the government has to use at least testimony about the methamphetamine to prove its possession with intent to distribute or conspiracy case, that bad faith is not a necessary element, and that we simply need to show that the evidence can't be found any other way, the meth can't be available to or tool any other way, and that it was potentially exculpatory. And then with respect to the packaging, our position is that bad faith doesn't need to be shown because the packaging was definitely exculpatory in the sense that Mr. O'Toole's fingerprints either wouldn't have been on it or wouldn't have been on it, and the fingerprints of other individuals would have been on it. And in both of those situations, the packaging would have definitely been exculpatory. And in that case, we wouldn't need to show bad faith either.
But I thought that when we look at whether it's potentially exculpatory or clearly exculpatory, it's the perspective of the reasonable officer we're looking from? Is that not right? I mean, from a reasonable officer's perspective, the reasonable officer doesn't know his fingerprints aren't on it. And
I think what the reasonable officer knows is it's going to be extremely material to the defense to be able to test the packaging and see whether fingerprints or DNA are on it.
I'm just saying, I'm not sure we can start from the conclusive presumption that his fingerprints are not on this packaging, because a police officer wouldn't know that.
I agree with that, except to the extent that I would say that the reasonable officer in that position is never going to conclusively know without conducting tests that fingerprints aren't on that packaging, and that's the problem with destroying the packaging.
But I understand, but under the law, doesn't that matter? I mean, as I understood it, the primary framework is if you know it's going to be exculpatory, you don't have to show bad faith. If it's potentially exculpatory, you have to show bad faith. And from the officer's perspective, following up on Judge Harris, I mean, it's maybe potentially exculpatory, but it's not knowingly exculpatory. Do you agree? Am I missing the law on that?
I think to the extent that's the law, it's been questioned or criticized in cases like the Elliott case, which I read as saying that if that were the case, if that were the law, and again, I think we can presume that law enforcement is generally not corrupt and they're generally trying to do the right thing and all of that, so I add that caveat.
Right.
But if that were the law as you pose it, it would always be the case that evidence would almost always be the case that evidence would always be potentially
Yeah, because we have,
exculpatory
like,
only.
There's all Brady evidence. I mean, that is on its face exculpatory, and that's why if the police destroy it, it doesn't matter whether they do it in good faith or not. I mean, there's lots of evidence that is, sadly, we have enough Brady cases to know that that kind of evidence is out there. facially exculpatory, nevertheless not turned over or destroyed, and that just seems like that's in a different bucket.
Well, what I would do, again, Your Honor, is point the court to the Elliott case. I understand that it's not mandatory authority, but I find the reasoning there very persuasive, where it says that were that the case, law enforcement could act in a corrupt manner, could destroy evidence, and we would never be able to know, we'd never be able to test it. You know, Judge King authored an opinion, U.S. versus Johnson, a couple of years ago. One of the things that U.S. versus Johnson seems to focus on is the importance of developing a thorough record about what's happened with the evidence. My belief, you know, and obviously I'm not in your mind, Judge King, but the way I read that opinion is that what you're saying is that more circumstances matter than just whether, in an objective sense, this is black or white Brady evidence, subjectively Brady evidence. And that's kind of my problem with the overall case here in general, is that as the lawyer who tried the case, looking at the particular defendant here and looking at the evidence against him, it's about the weakest I've ever seen, and that goes to the issue with destruction of evidence as well. Judge Cogburn, I think, did an excellent job conducting a very lengthy hearing on the issue of the evidence being destroyed, but the hearing never got to the bottom of the issue with the packaging. It never properly separated the issue, as I hope this court will, of analyzing the methamphetamine or the alleged methamphetamine versus the importance of the packaging, which to me is far more important and an easier call, because I do think I have to concede that the methamphetamine would merely have been potentially exculpatory, although again, I would take the position still not subject to the bad faith factor because it was necessary for the government's case through testimony. I think there's some cases that say that.
So, just let me stop you there, because maybe I've missed that. You think our law says if the evidence is necessary for the case, the bad faith doesn't apply, and your position here is that it's, I guess this is what Judge King was saying, couldn't be proved without the actual meth?
So the way I read the Belcher case, and again, I want to be very clear, I've never taken the position and I'm not taking the position that Belcher is advocating for overturning Youngblood or anything like that, but I think its reasoning is very instructive.
Okay.
And the way I read the Belcher case is that what the court is saying there is that in Youngblood, the destroyed evidence, the government didn't have to use the destroyed evidence to prove its case. It proved it in other ways, right? And in that situation, a bad faith exception might apply. But when the government absolutely has to use either testimony about the meth or anything connected with the meth to prove its case, then the bad faith exception wouldn't apply. And the reasoning there would be that that kind of evidence is so important that it deserves a special kind of scrutiny, a special kind of attention. But I also want to make sure the court understands that even if we do need to prove bad faith, we think we can do it here. And the reason we think we can do it is there's Agent Rios, the case agent here, has engaged.
Before you give us your reason, is the standard that we review that clear error?
I believe so, yes. So in terms of,
So you're saying Judge Cochran clearly erred in his ruling on the bad faith issue?
yes, Your Honor, I'm saying Judge Cogburn clearly erred by ignoring the evidence of the pattern that the case agent had here of presiding over, or I should say supervising, cases where material evidence was destroyed. At the trial level, both in the briefing and in hearings, I drew the court's attention to a case called Cabrera-Rivas, which this court also dealt with on appeal. But in Cabrera-Rivas, Agent Rios was the supervising agent in a case where a video recording of the defendant's immediate post-arrest interview was destroyed. In that case, the destruction happened because I believe it was the Gaston County Police Department's video recording devices and storage systems were set to automatically delete evidence every 7 days. And normally, what would happen would be law enforcement would go in when there was evidence that was potentially exculpatory and protect it, stop the auto deletion. There, the evidence was deleted. We made a record. We examined Agent Rios about that. His explanation was extremely thin. And then 2 years later, we have another situation happening, in this case where Agent Rios is involved in a situation where evidence is getting destroyed. And our belief is that that pattern, even if it's a pattern of gross recklessness, I don't think we have to accuse Agent Rios of doing anything that's necessarily corrupt, but that pattern of gross recklessness is enough to demonstrate bad faith. And again, that's something that's contemplated in the Elliott case involving the destruction of the glassware. There are other, I would suggest, indicators of bad faith that particularly with the troubling pattern of Agent Rios and Cabrera-Rivas and here, in the aggregate point to bad faith. One is the evidence at the hearing that the government wasn't concerned enough about the destruction of the methamphetamine and packaging, in this case, to conduct an internal investigation, to take any remedial measures, to discipline Agent Rios, or to do anything at all that showed that it was troubled by what happened, other than make some offhanded remarks to Judge Cogburn. To me, that's extremely troubling, that evidence would, even according to the lead chemist who tested the drugs here, evidence would be destroyed for the first time in 7 years, so it's of her testing drugs, so it's a remarkable event in her experience. And the government doesn't take any remedial measures of doing internal investigation whatsoever. And then there's the other, what I would call red flag factor or suspicious factor, which is that shortly before trial in this case, we learned that the government intended to send Agent Rios out of the country during trial, making him unavailable to testify. And we had to attempt to obtain a subpoena and raise the issue with the court to remedy that. But their position was that it would be sufficient for him to testify at the motion to suppress and that he shouldn't be required to testify at trial. And although he did
You
ultimately—
didn't know that those two events were connected intentionally.
I don't. Again, Judge, it's a circumstantial thing, and the argument is sort of where there's smoke, there's fire. So we've got the pattern of Cabrera-Rivas and what happened here. We've got the failure to do any internal investigation or take remedial measures. We've got trying to send Agent Rios out of the country during the trial. We've got in terms of the way that this supposed error happened, we've got the issue of, my understanding is that this happened, that the testimony is that this happened because Rios didn't double check case numbers, didn't take any kind of safeguards to double check that the wrong evidence wasn't being destroyed. And again, that's a sort of recklessness that I would suggest that the Elliott case points to as a evidence of bad faith, as an indicator of bad faith. And so we don't think bad faith is something that we need to show, but we think if we need to show, we can show it. With my small amount of remaining time, I'd like to briefly touch upon our argument that count 3 should have been dismissed because of the lack of evidence that a firearm was used in furtherance of the crime alleged in count 2.
Count 3 is flawed, is what you say?
Yes, Your Honor.
The proof is flawed.
The proof is too weak. And the main thing I want to focus on the court there, because I have so little time, is that count 3 isn't based on the conspiracy. It's based on the events of November 19th at the hotel. And
you made a motion for judgment of acquittal and it was denied.
that's correct, Your Honor, and for a new trial. And again, quickly there, the factors would be that Mr. O'Toole was never in the hotel room with the alleged drugs, and that he wouldn't need a firearm in that situation because any dealing that happened on that day occurred between Mr. O'Toole and Boone. They were each other's alleged suppliers, even according to Boone. They were friendly, they were sleeping together, they were sharing a hotel room in which they slept together. So obviously O'Toole trusted and felt comfortable enough around Boone that he wouldn't have felt like he needed a firearm to protect himself. So and we argued this extensively in the brief as well, but our position would be that the evidence was by far insufficient there. Thank you.
Thank you very much, sir. You've reserved some rebuttal time.
Yes, thank you.
Ms. Ray?
May it please the court, Amy Ray for the United States.
Good to have you here, Ms. Ray.
Thank you, Judge King. I sure appreciate that. I would like to begin by just providing a statement from Arizona versus Youngblood about what the standard is, but I also really want to take a minute to rebut the suggestion that there's any evidence of bad faith in this case, because I don't think that Mr. Turpening accurately summarized some of that evidence, and I really want to address that on behalf of Agent Rios and our agents in this case. So first of all, in terms of Arizona versus Youngblood, the Supreme Court said very specifically that it was unwilling to read the fundamental fairness requirement of the Due Process Clause to impose upon the police a requirement that they preserve all material that might be of conceivable evidentiary significance. They made very clear in Arizona versus Youngblood, and this court has never said anything else, that if all it is potentially exculpatory, then there is a requirement that the defendant show bad faith. Belcher and Elliott are both district court cases, and neither undermines the general principle, nor of course could they undermine the general principle that bad faith is required. But because Mr. O'Toole focuses on those two cases, I will just note briefly that in Elliott, the evidence that was destroyed within hours of the crime. And it was methamphetamine lab evidence, and the assertion was that it would be, that there might have been fingerprints on that evidence. And in Elliott, the court said that they had shown bad faith because there was no way, that there was no justification or policy. But that was a district court case. I don't think it helps. In Belcher, there was a destruction of the marijuana plants. I don't think the court got it right in Belcher that it could just ignore Arizona versus Youngblood and not require a showing of bad faith. But that said, it was a destruction of marijuana plants before they were tested. Completely different than what happened in this case. So this court has never suggested, and in fact, in Cabrera-Rivas itself, which Mr. Turpening and I both happen to have handled, this court rejected the due process claim in part because there had to be a finding of bad faith and negligence wasn't sufficient. So to address the specifics of some of what Mr. Turpening suggested about Cabrera-Rivas and Mr. Rios' conduct, in Cabrera-Rivas, there was no evidence that Agent Rios was the supervisor of Michael Vargas, who was the person that failed to preserve the evidence because he failed to make a recording permanent before the 7 days. He was the case agent, but he also said he was the undercover agent. He didn't participate in the interview. He had a co-agent. I don't think that Cabrera-Rivas in any way supports the suggestion that Agent Rios was responsible for the failure in that case. In fact, he said in testifying, and this evidence is before this court because this court has, because Mr. Turpening put this in the district court, but Agent Rios explained, yeah, the task force officer didn't preserve the recording, but he didn't supervise the task force officer in that work. And there wasn't any evidence that he suggested that he did. Now, in this case, the suggestion that the government didn't undertake an investigation that it should have undertaken is not a fair one, in my opinion, because the government knew exactly what happened, and we've provided the emails that show that the case number was 16 digits long. It was the same sort of case number, and then you have an evidence number. And only the last 5 digits are different. And the emails reflect that Mr. Rios was asked on the same day by the Department of Homeland Security personnel, do you want to destroy this evidence? One was evidence that was seized from Boone's home that could have been destroyed properly because he had already pleaded guilty, although frankly, I would have counseled against that. That's okay. And the other piece of evidence was the evidence that we're talking about in this case. And she sent that to Agent Rios on the same day and said, hey, can we destroy this evidence? Agent Rios sends it to Regina Pack, who was the assistant U.S. attorney at the time, And he refers to the evidence that could have been destroyed. Boone, can we destroy this? She says, well, is this Boone? He pleaded guilty. Yeah, we've confirmed that's the same. She says, okay, you can destroy that evidence. Then in August, the personnel from Department of Homeland Security on 2 consecutive days says, hey, I want to remind you, can we destroy this evidence? And he says yes, and he just mistakes those 5 digits. And so we know what happened. He was asked kind of at the same time about 2 related evidence, like related insofar as Johnny Boone was related in both cases, and that's the name of the defendant that these investigations were conducted under. And Agent Rios absolutely, and I give him some credit for this, said from the beginning, I'm embarrassed, I haven't done this in 30 years, I'm really sorry, this was a mistake. And the government also, our assistant U.S. attorneys got up to the court and said, we made a mistake here. So the investigation was done in the district court. The district court itself conducted the investigation of what happened in this case. And those who were responsible for the mistake, and it was a mistake, took responsibility. I don't think that that due process or any other requirement or even just simple fair play requires more than that. They acknowledged the mistake, and certainly nobody. That error, by the way, harmed the government much more than it did Mr. O'Toole, because we didn't have that. He was able to make that an issue, and even argued in closing argument. Both the defense and the government said this is a problem for the prosecution. It wasn't a problem for the defense. The chances that they were going to find, even if that plastic bag, first of all, difficult to find fingerprints on plastic, but even if it weren't, the possibility that his fingerprints weren't there would not have undermined what I must respectfully suggest is very strong evidence of guilt in this case on every single count. We had the 2 co-conspirators testify to specific dates and specific quantities. That's all we needed. We didn't need the methamphetamine. We had it tested. Nobody disputes that it was tested. Mr. Turpinning suggested that that Mr. O'Toole wasn't seen in the room. Not true. Officer Cheney testified that he was coming out of the room when Officer Cheney approached. So there was testimony that he had been in the room, and your honors are familiar with the facts, so I don't think I need to review those unless your honor has your honors have any questions about that. But I just do want to say that having handled many of these cases, of course, I don't think this evidence is weak at all on any point. In terms of the gun, Johnny Boone testified that Mr. O'Toole carried a big boy all the time, and it was that gun that was found right next to the motorcycle that Mr. O'Toole earlier had asked to go to. So plenty of evidence that he possessed it in further of a drug trafficking offense, plenty of evidence tying him to that, and I think that the district court got it right on every score here and did not clearly err on the bad faith determination, which was one of credibility in any event. If your honors don't have further questions, I respectfully request that this court affirm the judgment of the district court. Judge Quattlebaum.
Yeah, neither of you talked about it, but I got kind of turned around on the sentencing discussion.
Uh-huh.
And so it feels like a lot of it, the core of the issue is whether the district court sufficiently found the 525 grams.
Yeah.
So on that, let me just stop there.
Mm-hmm.
What's the evidence, or tell me why, to the extent that's an objection?
Sure.
Tell me how we know the district court found that there were 525 grams in terms of the sentencing.
Well, the district court overruled the drug quantity objection. So Mr. O'Toole objected to that. Had to be 500 grams to get to the offense level. I think it was 34. And so the district court overruled that, so we know he found it. How did he find it? Why did he find it? Well, Johnny Boone testified that the 318 grams of methamphetamine that he was sitting in front of when the officers came into the door was methamphetamine he'd earlier bought from O'Toole at his trailer.
Right.
And then.
I understand the testimony in the record.
Yeah.
Even at sentencing
Yeah.
about it. What
Okay.
I'm trying to focus on, what it seemed to me was Mr. O'Toole's questions about whether the district court had adequately explained its
Okay.
findings.
Yeah.
And he complains about or cites the reference to the jury finding on possession as maybe inconsistent with a finding or insufficient to be a finding. I'm not entirely sure. I'm just
Okay.
trying to understand the sentencing issues a little better.
Right, okay, and I apologize if our brief didn't clear that up sufficiently. So there are sort of two issues that I think Mr. O'Toole tries to conflate a little bit, in all honesty, in terms of trying to untack the 500-gram finding. So there's a legal issue on the question of the jury's special verdict for the conspiracy count, which would trigger the 10-year mandatory minimum, because the jury found generally that the conspiracy involved more than 50 grams, which would, but then there's a Fourth Circuit decision, I think it's Foster, I can't remember, that says it's got to be reasonably foreseeable to O'Toole. The jury didn't make that finding.
Right.
So as a technical matter, the mandatory minimum didn't apply to the conspiracy count. But it does apply to the substantive drug trafficking account, because the jury found in that case, in the special verdict, it was adequate. That finding really has nothing to do with the 500-gram finding.
It's just whether you have to have some attribution to him, and since they have it on the possession account, he's kind of saying we don't need to.
Well, I think on the possession count, we got the mandatory minimum satisfied, although Judge Cogburn's sentence is above the mandatory minimum, so I don't think it really matters. And didn't say he was confined by the mandatory minimum in any term. And then the sentencing guideline issue is relevant conduct. And so in that, we're not bound or restricted by the jury's special verdict in any way. The judge just has to find that the evidence supports that there was at least 500 grams were reasonably foreseeable in the course of the conspiracy. And we do have not only the evidence of that 500 grams, but of course the other transactions. I think that Mr. O'Toole does make some assertion that the district court's findings were inadequate, but we recite in the brief and have the joint appendix citations in our brief where the district court absolutely looked at that question and said, yes, it's 500 grams and I'm overruling you because there's enough there. And I'm trying to see if I have somewhere, I think I have that. Let's see. Okay, well, yeah, I put it in my brief. I think that's probably the best I can have. He did argue that the conspiracy verdict couldn't support the higher mandatory minimum. The judge doesn't really address that, and I don't think necessarily needed to. Any error on that would be harmless error anyway. He argues that the drug quantity is less than 500 grams, but it's not really clear why or how it could be less than 500 grams, unless you just attack basically saying he's not responsible for any of this, attacking the jury verdict in some ways.
Some of it felt merits oriented, but I think he said there's no adoption of the PSR, and there's no specific finding that there's 525 grams.
Yeah.
And so.
Well, okay. The judge doesn't have to make a specific, the judge finds a guideline range. And actually in the statement of reasons, I believe the judge does adopt and says that it adopted the pre-sentence report. So the statement of reasons should clarify that if there were any. But it doesn't, in overruling, a judge doesn't have to say, I'm overruling your objection and I'm finding 525 grams, right? The objection was, am I responsible for at least 500 grams? And the judge overrules, that's enough in terms of guideline determination. Now, when we go to the explanation, what you normally see in explanation of sentences, right, is where the judge is exercising its discretion. Now, it's found the guideline range, and does it explain adequately the choice of sentence? That isn't an issue in this case. It's not raised in this case. And I just don't think that this court's precedent requires that a district court explain with that kind of specificity or make a more granular finding than simply, no, I think you're responsible for at least 500 grams. And as long as the evidence supports that finding, that's all that needs to happen. There doesn't need to be there's no authority that I'm aware of that this court
And
has held.
even to the extent
Yeah.
there is, I mean, he does say, I'm going down 2
Oh, yeah.
levels.
Yeah.
He may not have said, well, I'm starting at 34 because of 500, but going down.
Well, in overruling the objection, he does say that. And I think that also in the statement of reasons,
Right.
it should reflect that he found a guideline, initial range of 34 and 1, which was 151 to 188, I think. And then he decides to go down 2 levels because of the destruction of the evidence and one other factor that's escaping me now because it's the pressure of the situation.
Guilty plea on the felon in possession, I think? Didn't he plead guilty to?
Yes,
one
he
count?
pled, thank you, Judge Harris, exactly right, because he acknowledged responsibility, so he goes down to 121. And because of the mandatory minimum of 120 that would have applied to the drug trafficking count, the substantive count, he went down a month above what the law would have required that he sentence in any event. I hope that answers your question, Judge Quattlebaum. I just don't think there's a requirement that the judge, he did overrule the objection, and I think the statement of reasons should clarify any, if there's any ambiguity at all. But I don't think there really is fairly any ambiguity when we look at the sentencing transcript. If your honors don't have further questions, thank you very much.
Thank you very much, Ms. Ray. Mr. Turping?
Thank you, Judge. So as my colleague acknowledges, and I appreciate it, as long as the evidence supports the drug finding, Judge Cogburn, I don't think he didn't have to give a reason, but I think the law is that he could have explained it less rather than more. The case I would point the court to is Chavez Mesa versus United States, 1585 U.S. 109 from 2018. And what I would suggest here is that the PSR relied entirely on the drug quantities from November 19th, not on the conspiracy to determine the 525-gram drug amount. And the undisputed, well, I guess we disputed it, but the testimony from the government's single witness on what was going on inside that room, Mr. Boone, was that there were 2 tranches of alleged methamphetamine. There were 207 grams that were attributed to Mr. O'Toole that I believe were found in a black backpack. And then there were 300 to 318 grams that were found in front of Mr. Boone that Mr. Boone testified Mr. O'Toole had sold him. So there's 318 grams of methamphetamine that are Mr. Boone's. And again, we're not determining drug quantity based on the conspiracy. So there's 318 grams that are Mr. Boone's, and there's 207 that are Mr. O'Toole's. 207 grams is less than 500 grams, of course, and the judge never explained that disparity. And so our position would be that at minimum, Mr. O'Toole should have been sentenced at an offense level 32 instead of an offense level 34. And I get that because of the variance and the way the variance works with the mandatory minimum, the difference may only be a month. But our job is to get it correct and establish precedent that's helpful in the future, and a month's a month. And so I would suggest that if the court understands and agrees with the way I'm describing the 2 tranches of drugs inside the hotel room and reads the testimony of Boone as explaining that the 300 grams were just Boone's, that there wasn't any evidence to support the 500 grams. So with that,
I'm sorry, this may be a dumb question, but I'm not actually sure I do understand your argument about the 2 sets of evidence. The one that belonged to Boone because he just bought it from your client, right?
right, and then it wasn't my client's.
Right, and then it wasn't your client's anymore, but why wouldn't it count as relevant conduct if he just sold it?
Oh, I think it's disputed whether he just sold it. I think the
Okay.
timing on when he sold it is unclear.
Okay,
And again, this is why I refer the court to cases like Chavez Mesa. The issue, again, is Cogburn didn't explain any of that. It was never taken up, we disputed it, and it just wasn't addressed.
Okay, but the question would be, was it relevant conduct for sentencing purposes?
I mean, the concept of relevant conduct is so broad that it's hard to credibly say that the answer is no.
I'm not even
But-
asking you for what the answer is, but that would have been the question that you would have liked to hear more from the district court on. Why
That's-
is this relevant?
That's
conduct?
exactly right, yes.
Okay.
Thank you, I appreciate it.
Thank you very much, sir. And I know you're court appointed, and I understand you went through the trial and this appeal.
Well, it's been an honor to do it, and
And,
I thank you all.
well, I want you to know that we appreciate your work
Thank you so much.
very much. We'll come down to Greek Council and adjourn court until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.